The case we're arguing today is in re Rowan Gasser, and want to make sure everybody can hear us okay. You're shaking your head, yes.
Yes.
And I can hear you, Mr. Cheek, and Mr. How do you pronounce your last name?
Grosscup.
Grosscup, okay. And Mr. Grosscup, I can hear you well. Each of you will have 15 minutes to present your argument. When the other side is arguing, please mute yourself so we don't hear any background noise and have any distractions. And then you, as the appellant, you'll have 15 minutes, but you can save up to 5 minutes if you so choose. So this is a case which involves a minor, so let's not use any children's names. And you can refer to them just as the child, or however you want to, but not by their actual name. Initials are okay as well. Any questions?
Question.
No.
All right, well then, I think we're ready to proceed.
Thank you, Your Honor. Honorable Judges Carr, Schaefer, and Teodosia, I request 2 minutes in rebuttal.
Thank you.
May it please the court. My name's attorney Lee Grosscup, and I'm here on behalf of the appellant in this matter, Jenna Gasser, the biological mother, legal custodian, and residential parent of the minor child involved. I first take this panel to the question of jurisdiction, and this stems from the code section of 3109.12, which states in relevant part that a relative may file a complaint in the court of common pleas requesting reasonable visitation. And I want to break that down into 2 categories. First, the phrase "in the court of common pleas." Now, the case law is clear on this matter. For example, in re JLM states that a juvenile court can exercise jurisdiction only if expressly granted the authority to do so by statute. And said in another way, in re Gibson, the juvenile court's jurisdictional power comes only from what the General Assembly has expressly conferred upon it. And out of those 2 cases, those 2 phrases, you hear the word expressly. Now, what in the sense of this case does expressly mean? Well, Webster's definition for this is in direct or unmistakable terms, explicitly, definitely, directly. Now, 3109.12, where it states in the court of common pleas, it does not directly or unmistakably say the juvenile court. And this is important because if you look at Revised Code 215123, the jurisdiction of the juvenile court, you will not see a grandparent visitation listed to file a new case. But you will find under Chapter 301, Title 31, the Domestic Relations chapter, you will find 3109.12 in that chapter. Now, in re EH, that case states that Chapter 3109 governs domestic relations matters that are within the province of the Domestic Relations Court. And also not included in my brief, but the code section 3105.011, jurisdiction over domestic relations matters, provides that domestic relation court has jurisdiction over 3109 under that chapter. So if you look just based on a pure code section and looking at the case law, 3109.12 is found under the chapter of domestic relations. It is not found under the juvenile court chapter. And even more so than that.
Counsel, that's not controlling though, is it? Just because it's found under a specific, I mean, I know, there's all kind of case law that says the name of the statute, for instance, doesn't necessarily control.
I would agree with you. It's not controlling, but it's one piece, and there's another piece to the puzzle in the fact that the case law says that the juvenile court only has jurisdiction if expressly granted the authority to do so. And that's where we have to come back to the phrase "in the court of common pleas" does not list the juvenile court. So therefore, based upon that analysis, to file a brand new case, a brand new grandparent visitation case, It cannot be filed in the juvenile court because it's not expressly granted the authority to do so, but it can be and should be and must be filed in the domestic relations court because that chapter is found under the domestic relations division as having the jurisdiction to do so. Now, another point to mention here is continuing jurisdiction. Now, the case law is clear that the juvenile court has the ability to have continuing jurisdiction over a child. But the key distinction here is you have to have the juvenile court properly have a case before it in order to exercise the continuing jurisdiction. Now, why does this matter? For a litigator in the family law, domestic relations arena, deciding where to file a brand new case is important. And it's the difference between filing a case in the domestic court or the juvenile court. And it's important for a litigator to know where to file and where you have the authority or the jurisdiction to file. And
Mr. Grant, question. Wouldn't you also agree that it differs county to county depending on what the court structure is in each county?
absolutely, absolutely. In fact,
And how does Wayne County differ from Stark County?
so Wayne County is not designated in Revised Code 2301.03. And for that point, Stark County, based upon that code section, designates Stark County as both a domestic relations court and a juvenile court, essentially merging the three judges together. That is completely different from Wayne County, where Wayne County is not designated in 2301.03. Based upon that, the juvenile court and the domestic court at Wayne County are completely separate. And therefore, you have to look to the code section to determine where can you file an original case. And this case is an original case. The juvenile court didn't have continuing jurisdiction over the child. And why this matters is the types of cases that a juvenile court traditionally hears on a day-to-day basis greatly differs from what a domestic court hears on a day-to-day basis. Now, a juvenile court, they will hear unfortunate facts of abuse and neglect and dependency. They'll hear cases of custody, of who's going to have custody over a child. Whereas a domestic court is more properly and traditionally hears cases of visitation, of intermongst of a family, who is going to a visitation over this child. And that's why I respectfully opine that that's why Chapter 3109.12 is found in the domestic relations court, because the types of cases that the two different, vastly different courts, two forums, hear two different types of cases. And that's why this matters, Your Honor.
Does it matter that there was no issue raised when the case was originally, when the motion was originally filed in the first place? Because this came on after the fact. So does it matter that nothing was ever filed or there was disputed in the first place?
It does not matter. So with jurisdiction, especially subject matter jurisdiction, it can be raised at any point in time. It can be raised after the fact, because the logic is if a court doesn't have subject matter jurisdiction over a case, the court doesn't have the authority or the power to issue orders over the individuals. And therefore, that's why in the Ohio civil rules, you're able to raise a subject matter jurisdiction challenge at any point in time. And it's also important to note that the parties cannot waive, the court cannot waive the issue of subject matter jurisdiction. And that's why you can bring it after the fact, and that's why we did here, because we're saying that this juvenile court didn't have the authority to issue orders in the first place. And then
what about the power of attorney that was pending too?
So the power of attorney, that's a great segue to that a motion was filed rather than a complaint. Now we have, and I will answer this by circling around. Now Mr. Bisden filed a motion to start this case, not a complaint. Now, Civ Rule 3A requires, in order to initiate an action, you have to file a complaint with the court. Now, the motion that was filed, you have to look at the primary purpose of the motion. The primary purpose of the motion was to request visitation. The power of attorney was added in there in the back as an exhibit. And I answer it with an analogy. Now, if I filed a motion to start a case, a motion to grant a divorce in the juvenile court, and I included in that motion for a divorce, I included in there in the back a grandparent power of attorney. The juvenile court would look at my motion, which was not a complaint. They would look at my motion and say, listen, the primary purpose of your motion is to file for a divorce. You need to move this case. You need to file your divorce complaint in the domestic relations court. They wouldn't say, oh, well, we'll still go forward on your divorce motion just because you've got the grandparent power of attorney added in there in the back. Now, there's no such thing as contemporaneous jurisdiction. There is such a thing as continuing jurisdiction, completely distinguishable. And to build off of the complaint being necessary to be filed instead of a motion, Martin v. Wayne County National Bank Trust and Investment Division made it crystal clear in the 9th District, saying that for the purposes of Civ Rule 3A, the filing of a motion cannot substitute for the filing of a complaint. And a motion is insufficient to invoke the trial court's jurisdiction. In order to invoke a trial court's jurisdiction, you have to comply with Civ Rule 3A, which is filing a complaint. And I point your honors to our exhibit 2A. It's part of the record number 3112. You can see it's clear as day. Mr. Bisden filed a motion asking for visitation, asking for an order, not a short and plain statement of the facts. You have to file a complaint with a short statement of the facts to allow the other side the opportunity to respond within 28 days to the allegations presented to the court. Now, you can absolutely file a complaint with a court, invoke the trial court's jurisdiction, and upon filing the complaint, you can come to a resolution and file an agreed judgment entry resolving the matter. But you gotta first start by filing a complaint, which did not happen here. And the lower court does not have the authority to waive Civ Rule 3A, and therefore the court never had jurisdiction to begin with, which is cause to void the original orders, and all orders after the fact void ab initio for lack of jurisdiction, lack of subject matter jurisdiction.
Is there anything to be made from, were all the other accompanying documents required to be filed at the time of filing a complaint also attached at the time they filed this motion?
I don't believe so. I don't.
None of the parenting proceeding act, none of the other documents that are required under a domestic relations court would have been filed with this as well?
Correct.
CCJ, EA, none of those other documents?
I don't believe so. I'm reviewing the record. I'm looking right here at the certified copy of the trial court docket. I don't see those documents having been filed. In fact, if you look under number 5 of the docket report, you can even see that the lower court, there's a note on the right-hand side that per Magistrate France, file this as a motion for grandparent visitation. The clerk of courts, you can see they didn't even know what to do with this because it wasn't a complaint, it was a motion. And you could see there, yeah, per Magistrate France files a motion for grandparent visitation, which indicates the clerk of courts didn't know what this was. There weren't other documents that are necessary to go along with it. It's just coming to a court and saying, motion out of nowhere with no case pending, asking to adopt an order. Now, why this is incorrect, it's analogous to me taking an agreement of visitation and filing a motion with the local municipal court and say, local municipal court, can you make this an order of the court, this visitation an order of the court? It's also analogous to me taking this motion, this agreement and going to the federal bankruptcy court and saying, I'm just going to file a motion. I know you're a court. Can you please order this as an order of the court? You can't do that.
Counsel, you're into your 2-minute rebuttal if you'd like to save that.
I would not like to say that. I'd like
Okay.
to continue on, Your Honor.
Okay.
And I'm going to move into special weight. Now, in this case, the Due Process Clause of the 14th Amendment protects the fundamental rights of parents in the control, custody, and care of their children. Troxel says that you have a presumption to be acting in the best interest of the child as a parent. In this case, the fundamental right was not honored by the court. Special weight in accordance to revised code 3109.051D, factor 15. It was not provided for Ms. Gasser in this matter. And how do we know that? Well, if you turn to A50 of our supplemented appendix, the magistrate stated one sentence for the wishes and concerns of the parent. She said, mother wishes for grandparents not to have scheduled visitation. Now, the magistrate goes on to say that it's given weighted consideration to mother's position concerning visitation. A position is completely different from the wishes and concerns of the mother. The wishes and concerns of the mother is the reasoning behind the position. And we know that the magistrate didn't give those wishes and concerns special weight, even some special weight, because if you turn to A51, the trial magistrate states that it doubts the legitimacy of mother's concerns. The magistrate goes on to say in A46, paragraph 179, much of mother's testimony was not credible. This magistrate is telling the world, whoever reads this opinion, that it doesn't believe mother's wishes and concerns are legitimate, and it frankly doesn't believe mother from the very beginning. Now, that's not up to the trial magistrate to decide, because the trial magistrate, pursuant to the fundamental right of Ms. Gasser, has to give special weight to the wishes and concerns of the mother, and that didn't happen. And the lower court took it one step further, and this is my final point because I see that I'm running out of time, that the lower court made sure that Ms. Gasser had the burden. Now, traditionally, yes, if you are the moving party to modify, you would have the burden of proof. But this is not a traditional case. This case involves a parent with a fundamental right and non-parents with only a statutory privilege. And in order to honor that fundamental right of the parent, to honor the presumptions that that parent is acting in the best interest of the child, I ask that this court adopt the sister courts of the 12th District, INRI, NCW, that no matter if it's of original review or modification, that the court have the burden on the non-parent, even in a modification case, because as that court said.
Thank you, counsel.
Thank you.
You have 15 minutes. Mr. Chief.
Thank you. May it please the court, opposing counsel, I represent the appellees, Maria and Eric Baisden. I'll refer to them as the Baisdens. The Baisdens are the grandparents of the minor child in this case. This child is a 4-year-old at this point in time. The Baisdens request that the 9th District Court of Appeals overrule the assignments of error. The Baisdens submit the Juvenile Division of the Wayne County Court of Common Pleas has subject matter jurisdiction over the child to address grandparent visitation time. The Baisdens submit that the court-ordered visitation schedule granted to them with this child is in the child's best interest. I would like to address the spot where Mr. Grosscup left off, and that was with regard to the special weight consideration. And I think actually it makes sense to address her second and third assignments of error together, because they both have to deal with the statute 3109.051, and that's the statute that provides the factors the court must consider in determining the best interests of a child when deciding a grandparent visitation case. and there's a Supreme Court decision that's been cited by this Ninth District Court of Appeals that says that the special weight requirement is satisfied when the court considers the subsection of 3109.051D number 15, because that portion of the statute specifically identifies the parent's wishes regarding the requested visitation as a factor that the court has to consider. And I think it's pretty clear when you look at the judgment entry from the court from April that there was a thorough analysis of all those best interest factors, including best interest factor number 15. Now, I don't think that the court has to set forth every piece of concern or every piece of information that a parent gives as a concern or wish. I think it's sufficient for the court to acknowledge that that factor has been considered. And in this case, the court did consider that factor. The court even specifically references that the court gave consideration to that wishes of the parent in particular. I think maybe what I'm hearing from Mr. Grosskopf is that the mother thinks that the court has to take her wishes and concerns at face value and accept them as the fact. Well, I don't think that is so, and I'll explain why in a second. And I think the other thing I hear Mr. Grosskopf saying is that just because mother states that this is her wish, that the court has to follow what her wishes are, and that is not so either. I cited case law in my brief from the Second District Court of Appeals. I think is persuasive. It says that in this regard, just because a court has to consider the wishes of a parent, it does not mean that the parent's wishes regarding non-parent visitation are necessarily going to prevail. I think that the other thing I want to talk about in respect to mother's wishes are back to this, what I mentioned previously, is that mother, it sounds like, is saying the court has to take her statements at face value or as the fact. Well, again, I don't think that's the correct position to take. The court knows that the trial court has the discretion to determine the credibility of someone testifying, what weight to give that testimony. And it's clear the court heard what mom's wishes are, but the court didn't find it credible what her wishes are. You know, in this case, we have mothers testifying about her concerns, and yet mother also very clearly testified about such things as the child's close bond with the Baisdens, that the child enjoys going to their house. Mother also testified she had no question that the Baisdens provide a loving environment for the child. And I think it's important too that mother testified that she acknowledged the child is accustomed to spending the amount of time that he does with the Baisdens. So I on behalf of the Baisdens, they respectfully request that this court overrule the second and third assignments of error of the mother for those reasons. And I also want to add, there's some comments in the brief of the mother about the percentage of time or the number of overnights the child is to be with the Basins per the visitation order. And frankly, I didn't do the math, but it strikes me as what the mother is asking for is some bright line rule that says this number of overnights or this percentage of time is clearly excessive. I just don't think the law contemplates looking at a case that way. We all know, your honors know, that every case is different, every child is different. And there was a lot of testimony in this case. I think it lasted nearly 3 days. And so I thought that the highlights, as I already stated, are that the mother thought that the child was really well adjusted to being with the Basins. And I think what I'm hearing actually is that, and this sort of segues into the first assignment of error, I think what we're hearing is that the mother doesn't want there really to be any visitation order at all. She wants to dictate what times and under what circumstances the Basins see their grandchild. And I say that because I feel like the jurisdiction issue, frankly, could be a non-issue, because mother seems to be arguing that this visitation order should be made in order somewhere. It has a rightful place, whether it's in juvenile court or domestic relations court. Now, I'm not taking I'm not conceding that it should be in domestic relations court. I think it's, domestic relations division. Frankly, I'm not sure that it matters. So let me talk about this first assignment of error of the mother. The statute that's applicable here, 3109.12, it says that the parents of a woman and any relative of the woman may file a complaint requesting the Court of Common Pleas of the county in which the child resides grant them reasonable companionship or visitation rights. So what happened here, this wasn't just Mr. Basden. It was Mr. Basden, Mrs. Basden, and it was mother. The three of them together entered into an agreement. They together filed a joint motion with the court. Sure, it's not a complaint, but the three of them together filed a joint motion. So I want to mention this. I think this is sort of ancillary to the jurisdictional issue, but I think the fact that mother is taking up issue with the fact that it's called a joint motion instead of complaint, I think is somewhat disingenuous, because it was evidently her wish as well that the court make this schedule an order of the court. Now, when I say this schedule, that's the initial schedule, because the motion that's before the court was granted insofar as it modified the initial agreed upon visitation schedule. But I think the parties did what the statute calls for.
Well, not what the plain language calls for. Let's go back to that first sentence you read. It says may file a complaint, not a motion, a complaint, requesting the Court of Common Pleas, not a Court of Common Pleas. And when they're talking about the Court of Common Pleas, this is under Title 31, which governs domestic relations court. Doesn't the plain language of the statute indicate that a complaint has to be filed with the domestic relations court? And if not, where does the court get its jurisdiction? Juvenile court, since under 215123, what section of 215123 would you say gives the juvenile court jurisdiction? So multiple questions, but I'm curious as to what your response would be.
Sure. Yeah, I understood that there's multiple questions there, so I'll try and break it up a little bit. The statute doesn't use the words domestic relations division. The statute doesn't use the word juvenile division either, as you noted, and I said it says the Court of Common Pleas. And I think, as was discussed earlier, I think Judge Schaefer was bringing it up about, you know, what's the situation? How does Wayne County handle this sort of thing? And I think this partially answers your question. In Wayne County, you have a Court of Common Pleas. There's a division for juvenile, and there's a division for domestic relations. Domestic relations is usually in Wayne County handling married parents or non-married, or married persons getting a divorce. In the juvenile court, they're handling, of course, children's services cases, but this is not one of those. But they're also handling cases between non-married parents or situations where like this. I mean, this is not the first time Wayne County Juvenile Division has handled this sort of case. So I think there's a lot of other cases out there that hang in the balance depending upon your ruling in this case. So that last comment doesn't really answer the question. But the first part of it was this, is that the statute doesn't designate juvenile or domestic division. Wayne County has one common pleas court and two divisions, and Wayne County has historically operated that non-married parent cases are in the juvenile division. So to answer your question partially, I feel like there's a distinction without a difference, at least in Wayne County. So I don't see the problem with anything being filed in a case like this in the juvenile division.
Can I ask something? Sorry, and it's along the lines of what Judge Tidosio just asked. Is it possible to transfer the case from one division to another division within the same court?
I don't know the answer to that question. I mean, off the top of my head, I'm aware of the domestic relations transferring to juvenile, of course, by statute, if there's a finding of parental unfitness in both parents. I'm certainly aware of that. I'm sure you are as well. But going back from juvenile to domestic relations, I'm not sure if there is. I'm certain, however, that our domestic relations court is going to need Your Honor's direction, telling him, or telling, I didn't mean to say him, there's them. There are two judges here in common pleas domestic division. I think they would require direction from you saying they need to accept this case. But this whole jurisdiction issue could really just be a non-issue. If the mother really wanted, we could just put on the agreement or the court-ordered visitation schedule in one court or the other, and we would be done, and we wouldn't perhaps have been fighting for 3 days in court.
Counsel, you're almost out of time. I really would like just to hear your answer to Judge Teodosio's question in regard to motion versus a complaint.
My position on that is that we've got three people here that all intended to do one thing, and that is to get this visitation schedule made in order of the court. And I think that putting form over function really defeats the whole purpose of the underlying nature of the case, is what's in the best interest of the child. That's what's important here. And I think that shouldn't be lost on the court. I'm sure it's not. But that's what we're dealing with here. We're dealing with a 4-year-old child and a mother who doesn't want there to be a visitation order that the child is accustomed to spending with his grandparents. And if you vacate the order for visitation like the mother wants, mother's going to be in complete control. So I'm not trying
Counsel,
to
Counsel, you're out of time. Thank you. Thank you.
Thank you.
Mm-hmm. And you've already used your rebuttal time. So thank you both for your arguments that you presented to the court today. The court will take the matter under advisement and will issue a written opinion that will be sent to both sides. Also, we do release our opinions, as you know, probably electronically. So you can look on the Supreme Court website or our website for that as well. So thank you very much, everybody. Stay safe. Thank you for appearing this way. Bye-bye.
Thank you. Take care.
Thank you, Counsel.